At 10:01 a.m., the Supreme Court released a decision that sent shockwaves through Washington. The ruling appeared quietly at first, posted to the court's official docket like hundreds of decisions before it. There were no sirens, no dramatic announcements echoing through the halls of government, just a document dozens of pages long uploaded to a website. But within seconds, staffers across the Capitol realized something extraordinary had just happened. The decision was historic, and its consequences were immediate. The court had blocked a major federal policy that had defined months of political debate, legislative maneuvering, and executive strategy. The vote was decisive, 6 justices in the majority, 3 in dissent. The 6-3 ruling did not merely question the policy, it shut it down. At the center of the decision was a constitutional argument about the limits of federal authority. According to the majority opinion, the executive branch had overstepped the authority granted to it by Congress. The language of the ruling was calm and deliberate, but its meaning was unmistakable. One sentence in particular began circulating through Washington almost instantly. The statute, the court wrote, does not grant the executive branch the authority to take this action. That line alone carried enormous weight. It meant that a policy once considered central to the administration's agenda had just been declared legally unsustainable. The timing made the shock even more intense. Inside the White House, senior officials were in the middle of their morning briefings when the decision arrived. Legal advisors opened their phones and laptops to read the ruling as soon as alerts appeared. Within moments, printed copies of the opinion were being rushed into meeting rooms, where policy teams gathered around conference tables trying to understand the full scope of the decision. Across Pennsylvania Avenue on Capitol Hill, congressional staffers experienced the same moment of realization. Phones buzzed simultaneously across offices in the House and Senate. Legislative aides hurried down corridors carrying freshly printed summaries of the opinion. Lawmakers preparing for committee hearings suddenly found themselves confronting a new political reality that had emerged without warning. Within minutes, senior congressional leaders began requesting briefings from their legal teams. The ruling was not just another Supreme Court decision buried deep in the daily legal cycle. It struck directly at the intersection of law, politics, and government power. That combination guaranteed one thing: Washington would react immediately. Legal analysts quickly began parsing the details of the majority opinion. The court's reasoning centered on a familiar constitutional principle: separation of powers. Congress writes the laws, the executive branch carries them out. When an administration attempts to expand its authority beyond what lawmakers clearly authorized, the courts may intervene. In this case, the majority concluded that the federal policy in question rested on an interpretation of the law that stretched far beyond its original intent. That interpretation, the justices argued, could not stand under the Constitution. The dissenting justices offered a starkly different perspective. They warned that the majority's decision could limit the federal government's ability to respond quickly to national challenges. According to the dissent, the policy fell within the executive branch's legitimate authority. But the dissent did not change the outcome. The majority opinion carried the force of law, and with it came immediate consequences. In government agencies responsible for implementing the now blocked policy, confusion spread rapidly. Officials began reviewing internal directives to determine which programs must halt immediately. Regulatory teams debated how to respond while awaiting guidance from the Department of Justice. Policy experts who had spent months designing implementation strategies suddenly faced the possibility that their work had been rendered irrelevant in a single morning. But the legal consequences were only part of the story. The political consequences were just beginning. In Washington, a Supreme Court ruling that blocks a major federal policy does more than settle a legal dispute. It reshapes the balance of power between institutions. It forces lawmakers to reconsider legislative strategies. It compels the executive branch to rethink how it exercises authority. And most importantly, it ignites immediate political conflict. Within minutes of the ruling's release, the first reactions began emerging from Capitol Hill. Some lawmakers praised the court for defending constitutional limits. Others condemned the decision as an example of judicial overreach. Television networks interrupted scheduled programming to cover the breaking news. Reporters rushed to congressional offices seeking statements from elected officials eager to frame the narrative. What had started as a quiet legal posting on a court website had suddenly become the dominant political story of the day. Because this wasn't. By the afternoon of the Supreme Court's ruling, one thing had become clear across Washington. The legal battle might be over, but the political battle had only just begun. The court had spoken with final authority on the constitutional question in front of it, striking down the federal policy that had triggered the case. But in the American system of government, a Supreme Court ruling rarely ends a political fight. More often, it simply changes the battlefield, and almost immediately, lawmakers began preparing their response. On Capitol Hill, conversations shifted from outrage and celebration to strategy. Members of Congress who opposed the ruling began discussing one option that appears almost every time the court blocks a major policy: new legislation. If the court had determined that the executive branch lacked clear authority under existing law, Congress could theoretically solve that problem by writing a new statute that explicitly grants that authority. Several lawmakers announced plans to introduce bills designed to restore the policy framework the court had invalidated. Their argument was straightforward. If the justices believed the law did not clearly authorize the policy, Congress could simply rewrite the law to remove any doubt. Draft proposals began circulating among legislative staff as committees responsible for the policy area prepared to examine possible legislative fixes. But passing new legislation in Washington is rarely simple. Any new law would need to move through both chambers of Congress and survive the deeply divided political environment that defines modern policymaking. Supporters of the court's ruling quickly signaled that they would oppose efforts to recreate the policy through legislation. In their view, the decision represented a necessary correction that restored constitutional limits on federal authority. The idea of rewriting the law to revive the same policy immediately became another political flashpoint. For some lawmakers, the response required an even more dramatic step. A small group of legislators began discussing the possibility of a constitutional amendment, an extraordinarily rare and difficult process that would require approval from 2/3 of Congress and ratification by 3/4 of the states. Amendments are almost never proposed in response to individual Supreme Court decisions, but the conversation itself illustrated how deeply some members of Congress viewed the stakes of the ruling. Whether realistic or symbolic, the suggestion reflected the intensity of the political reaction unfolding across Washington. Meanwhile, inside the executive branch, legal advisors began exploring another path forward. While the court had blocked the specific policy under the statute cited in the case, administrations often look for alternative legal authorities that might allow them to pursue similar goals through different mechanisms. Government lawyers reviewed existing laws, regulations, and administrative tools, searching for possible avenues that could achieve at least part of the policy's objectives without conflicting with the court's reasoning. This type of legal maneuvering is a familiar part of Washington's institutional chess game. When one pathway closes, policymakers look for another route that remains open under the law. At the same time, legal scholars across the country began debating the broader implications of the ruling. Law schools, policy institutes, and constitutional experts quickly published analyses examining how the court's reasoning might affect future government actions. Some scholars argued that the decision would strengthen democratic accountability by forcing Congress to clearly authorize major policies instead of allowing federal agencies to expand their authority through interpretation. Others warned that the ruling could slow the government's ability to respond quickly to complex national challenges by requiring more explicit legislative approval before agencies act. These debates did more than interpret the court's opinion, they helped shape the political narrative surrounding the decision. Back on Capitol Hill, congressional leaders began considering whether to launch formal investigations into the policy that had been struck down. Oversight committees discussed holding hearings to examine how the executive branch had interpreted the statute in the first place. Lawmakers wanted to understand whether the administration had knowingly stretched the boundaries of its authority, or whether the legal dispute represented a genuine disagreement over how the law should be read. Congressional investigations often serve both legal and political purposes, allowing lawmakers to question officials, gather documents, and place their arguments into the public record. As discussions continued, it became increasingly clear that the Supreme Court's decision had not ended the policy debate, it had intensified it. The ruling had shifted the conflict from the courtroom back into the political arena, where lawmakers, executive officials, and legal experts would now compete to define the next phase of the dispute. Some leaders called for compromise, suggesting that Congress might craft a new legislative framework capable of attracting bipartisan support. Others doubled down on their positions, framing the ruling as either a victory for constitutional limits or a dangerous obstacle to effective governance. Washington thrives on conflict, and the court's decision had delivered a new one. In the coming weeks, legislative proposals would be introduced, hearings scheduled, and legal strategies refined as both sides attempted to shape the policy landscape after the ruling. The constitutional debate that had begun inside the Supreme Court chamber was now unfolding across the entire political system, because in Washington, power rarely disappears. It shifts, adapts, and searches for new pathways. And after the court closed one door, Congress was already searching for another. In Washington, some events pass quietly through the political system, leaving little trace once the headlines fade. Others become turning points, moments when the balance of power inside the federal government subtly but unmistakably shifts. The Supreme Court's ruling in this case now appears to be one of those moments. On the surface, the decision struck down a single federal policy. But beneath that immediate outcome lies a deeper constitutional signal about the limits of government authority and the roles of the institutions that share power under the American system. For decades, debates over federal authority have revolved around a central question: how far can the executive branch go when interpreting the laws written by Congress? Modern governments operate in an environment of enormous complexity, managing economic systems, technological change, environmental regulation, and national security challenges that evolve faster than legislation often can. Because of that complexity, Congress frequently passes laws that give federal agencies broad authority to implement policies within general guidelines. Those agencies then interpret the law, create regulations, and apply them to real-world problems. The arrangement has allowed the federal government to function efficiently, but it has also created recurring tension over how much authority agencies should possess. The Supreme Court's decision stepped directly into that tension. By ruling that the executive branch had exceeded the authority granted by Congress, the court reinforced a constitutional boundary that has been debated for generations. According to the majority opinion, major national policies with sweeping economic or political consequences must be clearly authorized by lawmakers themselves. Agencies and executive officials cannot simply discover vast new powers hidden within vague statutory language. That principle may sound technical, but its implications reach far beyond a single case. It affects how federal agencies draft regulations, how administrations interpret existing laws, and how Congress approaches legislation in the future. In effect, the court reminded Washington that power must travel through the channels the Constitution created. For the executive branch, the ruling represents a constraint but also a clarification. Administrations now face a higher legal bar when attempting to use existing statutes to support large-scale policy initiatives. Instead of relying on flexible interpretations of old laws, future presidents may need to seek more explicit authorization from Congress before implementing major changes. That requirement could slow certain policy efforts, but it also reinforces the idea that sweeping decisions should originate from elected lawmakers rather than administrative interpretation alone. For Congress, the ruling carries a different message, one about responsibility. If lawmakers want the federal government to exercise broad authority over major national issues, they must write laws that clearly grant that authority. Vague or open-ended statutes may no longer provide the legal foundation needed for large regulatory programs. That shift places greater pressure on Congress to draft detailed legislation capable of surviving judicial scrutiny. In a political environment often marked by legislative gridlock, that challenge may prove significant. The judiciary's role in this balance of power is both delicate and powerful. Courts do not create policy in the same way legislatures or executive agencies do. Instead, they interpret the Constitution and the laws passed under it. Yet, when the Supreme Court determines that a policy violates constitutional principles, its decisions can reshape the direction of government action just as dramatically as any piece of legislation. This case illustrates that dynamic perfectly. The justices did not propose a new policy framework or outline an alternative regulatory system. They simply concluded that the existing approach exceeded the authority granted by law, but that conclusion alone forced every other branch of government to reconsider its next move. The relationship between Congress and the judiciary becomes especially visible in moments like this. Congress possesses the authority to write new laws that respond to the court's concerns. The judiciary possesses the authority to review those laws to ensure they remain within constitutional boundaries. Together, the two institutions create a cycle that shapes the evolution of American governance over time. One branch defines policy, the other defines limits. When that interaction functions properly, it keeps the balance of power from drifting too far in any one direction. That is why many legal scholars now describe this ruling as more than a single legal victory or defeat. It represents a reminder of the structure that underlies the entire federal system. The Constitution does not simply organize government authority, it constrains it. Every branch must operate within boundaries defined not only by politics but by law. This ruling did more than block a law, it redrew a boundary. In the months ahead, Washington will continue debating what the decision means for future policies, future administrations, and future legislation. Lawmakers will propose new bills. Agencies will adjust their regulatory strategies. Courts will hear new challenges that test the principles established in this case. The political fight will continue, because it always does. But beneath that ongoing debate lies a deeper constitutional shift, one that will influence how power moves through the federal system for years to come. Because in Washington, power rarely disappears. It simply moves. And today, the Supreme Court moved it.